Good morning. So when I had more hair, I was a law clerk, and my judge, who had been a politician before coming to the bench, once said to me, when you speak, the two worst times to speak are after lunch, because everyone wants to fall asleep, before lunch, because they're hungry. And then he goes, yeah, and speaking at the end of the day is bad. He's like, yeah, and speaking early and everyone's tired. So he's like, yeah, it's really just bad to speak. I hope you bear with me, and I'll try not to delay food too long. But thank you for that very warm introduction. I'm delighted to be here at the the Virginia Law and Business Review Symposium. And the program here seems absolutely fantastic, touches on critical issues in antitrust law today. And I see from from the agenda a number of familiar faces, most of them friendly. Hopefully they'll be friendly afterwards. It's really impressive, I think, that you've invited a broad scope of panelists representing different views. As an antitrust lawyer, I think that competition in markets leads to better outcomes for society, but similarly, competition in the sphere of ideas leads us to the right, or at least better answers. And it's awesome to see so many students here. I think I was talking just before this that when I was in law school, before the internet, if you did this conference, there would have been the two students who did all the panels and nobody in the audience. But it is really an exciting time for antitrust law and at the division. So that's an indirect way of saying I hope you all consider joining the division and help us in our mission. Interns, volunteers, attorneys, whatever, they all would be much wanted, because it's a bit of an understatement to say we are busy these days, including in the courts of this very Commonwealth, in case you might have heard it about a small family firm, Google. And so we could really use your help. Okay, that was kind of funny. I mean, so although this conference is on antitrust and high tech, I actually want to start by going back in time to 1939, the year Metro-Goldwyn-Mayer released The Wizard of Oz, right? And so, a little worried that cultural reference is a little, so let me tell you about the story briefly, right? This tornado or twister transports Dorothy and her dog Toto from Dust Bowl, Kansas, it's filmed in black and white, to this magical world of Oz in glorious Technicolor, kind of like, the AI of the Depression. So Dorothy, desperate to return home, she searches for the Wizard of Oz, finds him, and he agrees to return her to Kansas if she and her companions will dispose of the Wicked Witch of the West. She's successful. The group comes back to the wizard, receives an audience, and he appears as this large, green, disembodied head surrounded by flames, intoning in this deep baritone voice, "I am Oz, the great and powerful." And then, like a politician, he actually doesn't live up to his promise. Dorothy and her companions stand stunned, terrified, and powerless before the great and powerful Oz. But not Toto. He finds a curtain, pulls it aside, and reveals a little old man with a bald head and a wrinkled face. Surprised, Oz quickly pulls the curtain shut, and we hear the deep, foreboding voice intoning, "Pay no attention to the man behind the curtain." But the gig is up. That's exactly what Dorothy and her friends do. They confront the man behind the curtain. He admits he's a humbug, and Dorothy eventually has to find her own way home. So that confrontation is actually a useful analogy for what I want to discuss today, which is refusals to deal and under the antitrust law. So back in 2004, the Supreme Court issued Verizon Communications versus the law office of Kirshner v. Trinko, which is one way to get your name to last forever in law, is to actually be the named plaintiff. The case addressed whether defendant Verizon had engaged in illegal monopolization by refusing to deal with one of its competitors. Now, some in the bar and certain companies would have us believe that Trinco is a great and powerful decision. Great because they would have us believe refusals to deal covers a broad range of conduct, and powerful because they would have us believe that Trinco virtually immunizes refusals to deal from any antitrust liability. And an example of this approach is the district court decision dismissing State of New York versus Facebook. So today, modestly, I hope to play the role of Toto, to pull back the curtain and to show you that neither Trinco nor refusal to deal is that great and powerful. Much like the Wizard of Oz, the real Trinco decision is far less than it appears. My remarks today draw in part on the amicus brief the Department of Justice filed earlier this year that explained the errors in the Facebook court's decision. So this is not to say that I'm suggesting companies, even monopolists, have a broad generalized duty to help competitors. It does mean, however, that the general principles of Section 2 law, the law on monopolization, apply to refusals to deal. It means that refusals to deal of the kind at issue in Trinco are highly context-specific and driven by the unique facts and circumstances at issue in that case. It does mean that specific rules for refusals to deal do not apply to a broad range of conduct that's at issue in digital markets cases. And it does mean that a unilateral refusal to deal that has the purpose to create or maintain a monopoly may violate Section 2, and that is a broad-based, factual, case-specific question. So although Toto was able to pull back that curtain in a matter of moments, take me a bit longer. Refusals to deal is a hot-button antitrust topic, and in digital markets in particular. Dealing with others is at the heart of what digital platforms do. They are multi-layered, intertwined networks that connect a variety of stakeholders. And so, when we investigate or challenge anti-competitive conduct in these markets, counsel is quick to latch on to the refusal to deal framework. And the mantra we hear time and time again stems from a selective, partial quotation from that opinion in Trinco. Quote, "The Sherman Act does not restrict the long-recognized right of a trader or manufacturer engaged in an entirely private business freely to exercise his own independent discretion as to parties with whom he will deal." Court's pronouns, not mine. Now, whether intentionally or by accident, they frequently omit the beginning part of that quote, "thus as a general matter." Thus as a general matter could apply to virtually every type of conduct that can violate the antitrust law. As a general matter, tying doesn't violate the law. As a general matter, exclusive dealing doesn't violate the antitrust laws. But instead, they interpret Trinco to forbid a refusal to deal only if the monopolist had a voluntary prior course of dealing with the rival before the refusal to deal. In other words, if you've never dealt with the rival before, you are under no obligation to ever deal with them. Others would go even farther and add additional requirements before addressing, what the court can address conduct involving refusal to deal. So let's take a look at the US District Court's decision to dismiss the Facebook case. Now, among other things, the state attorney generals alleged Facebook forbid competing social platforms from connecting to Facebook's network. And it forbid apps that connected to Facebook from linking to or integrating with competing social platforms. And eventually, according to the complaint, if an application that connected to Facebook could not develop what Facebook called its core functionality. And then according to the complaint, the theory was these policies allowed Facebook to neutralize competitive threats and maintain its monopoly position. In dismissing the allegations, the district court analyzed all of that conduct as a refusal to deal. So it should strike you as a little strange because it's not that Facebook wasn't simply refusing to deal with people, it was imposing conditions on people who were interacting with it. Some people will call that a conditional refusal to deal. In the court's view, however, it saw that distinction as semantic because one can always reword a unilateral, unconditional refusal to deal as a conditional one. Now that semantic framing overlooks a critical distinction. In an unconditional refusal to deal, a party is simply withholding its assets and services from the marketplace. In contrast, based on the allegations, Facebook made its platform available to app developers, but allegedly imposed conditions that interfered with, deterred, and prevented market transactions between the app developers and other companies. This is not to say that necessarily imposing conditions is illegal, just they're not refusals to deal. So we might say the term conditional refusal to deal is a little inartful. Conditional sounds like it's less restrictive than unconditional. But the conduct here, that's not so, right? In the situation where there are these additional restrictions, right, the company must meet the usual terms of condition to access the platform and then agree to other conditions that affect the marketplace. So we might actually be better to call them restrictive refusals to deal. So having defined refusal to deal broadly, the Facebook court applies a three-pronged test of their legality. The monopolist must have refused to deal against a rival with which the monopolist had a previously course of dealing, while the monopolist kept dealing with others in the market at a short-term profit loss with no conceivable rationale other than driving out a competitor in the long run, right? So you had to have been dealing with them before. You stopped dealing with them, you were dealing with others, you lost money, and there you have no other justifications. It's quite a little moat to build around addressing refusals to deal. And if Trinko stood for the propositions that the district court asserted, it would indeed be a great and powerful case, although I would submit it would be then a terrible case, which was actually the term Oz used in the book as opposed to the movie. The real Trinko, however, is far more modest. So let's start with Trinko itself. Now, historically, telephone companies Historically, telephone companies enjoyed a monopoly within their local service area. So in 1996, Congress tried to promote some competition within your local area. And again, I'm aware of my age, so just so we remember, back in the day, your phone had to be connected to a wire. You didn't carry it around. You had to have, to call someone in California, there literally had to be wires all the way from New York to California or under the ocean to London. So in 1996, to facilitate competition, the Telecommunications Act required incumbent local monopolists, telephone monopolists, to share their networks with competitors. The 1996 Act established a complex regime for monitoring enforcement and gave the Federal Communication Commission, a good agency but not as good as the Federal Trade Commission, an active role in policing the terms of sharing. So a law office brought suit alleging that Verizon, the incumbent monopolist for local telephone services in New York, refused to share its network with a rival. Ironically, the rival was AT&T, which itself had been a monopolist until the government had broken AT&T up in the 80s. Further, according to the plaintiff, that refusal allowed Verizon to maintain its monopoly in violation of Section 2 of the Sherman Act. The FCC had, in fact, found that Verizon had violated the Telecommunication Act in order for Verizon to share its network. So the court observed in analyzing the case, that antitrust analysis must always be attuned to the particular structure and circumstances of the industry at issue, affording a careful account of the pervasive federal and state regulation characteristics of the industry. So then the court found there was no violation, and I really want to talk about three issues that go to the core of its finding that I think are relevant to the kinds of issues you're interested in this symposium. First, the Supreme Court made the unremarkable finding that violating a regulatory requirement like the Telecommunication Act automatically establishes an antitrust violation. The court said, but just as the 1996 Act preserves claims that satisfy existing antitrust standards, does not create new claims that go beyond those existing standards. Second, it determined under the existing antitrust standards, Verizon's refusal did not violate existing antitrust standards. Finally, the court considered whether it should expand antitrust liability to encompass the type of refusal to deal at issue in Trinco. The court rejected this approach. In its view, the FCC had used its broad authority to promote competition. It thought that recognizing a new cause of action would achieve little, writing, where such a regulatory structure exists, the additional benefit to competition provided by antitrust enforcement will tend to be small, and it will be less plausible that the antitrust laws contemplate such additional scrutiny. At the same time, the court worried that a new cause of action would impose costs. Quote, judicial oversight under the Sherman Act would seem destined to distort investment and lead to a new layer of interminable litigation atop a variety of litigation routes already available to and actively pursued by competitors. Remember, though, all that policy discussion related to expanding existing antitrust law, not to limiting it. So as we think about what refusals to deal means today and in digital platform markets, neither the first or third issues say much, because they both depend on a regulatory structure very specific to how Verizon was regulated. That structure or anything like it does not exist for digital markets. So what matters here is, why did the court find that the allegations in Trinco failed to state a complaint upon which relief could be granted? But nothing in the Supreme Court's opinion in Trinco suggests an intent to completely upend Section 2 of the Sherman Act, or refusals to deal laws specifically. The court did not overrule any existing precedent. Instead, it recognized the continued validity of key cases involving refusals to deal and took care to distinguish Trinco based on its unique facts and regulatory context. The Trinco court did not expand the definition of refusal to deal. It did not address at all cases where a dominant firm imposed anti-competitive conditions when dealing with other companies, most notably Lorraine Journal versus the United States. There, the monopolist, a newspaper, violated Section 2 when it said, we will only accept advertising if you agree not to advertise for the local radio, our new potential competitor. Supreme Court found a violation. Judge Bork, who many of you may know, not an antitrust enforcement radical, always thought that was a good case, and in Trinco, court didn't even suggest that what was going on in Trinco somehow brought question to undermine Lorraine Journal. The takeaway is that the legal test for refusals to deal applies in really two narrow related situations, where the defendant outright refuses to provide a rival with a requested product or service, full stop, and where a rival challenged an ongoing deal with commercially disadvantaged terms. So, any conduct falling outside those two categories are judged under different legal standards. Turning to how the court analyzed the refusal to deal, again, the court relied on existing precedent. Since the early 20th century, in the United States versus Colgate and Company, I always like when it's an old case and the company's still around, Colgate. The Supreme Court has recognized that the right of a trader, this is going to be redundant and it's going to sound really familiar if you were listening like 5 minutes ago. The Supreme Court recognized the right of a trader or manufacturer to engage entirely in an entirely private business freely to exercise his own independent discretion as to parties with whom he will deal. Again, court's pronoun. But it went on to say that right exists only in the absence of any purpose to create or maintain a monopoly. Trinco simplified this language, but didn't overturn the analytical framework. To the contrary, the court said, the high value that we have placed on the right to refuse to deal with other firms does not mean the right is unqualified, and that, under certain circumstances, a refusal to cooperate can constitute anti-competitive conduct and violate Section 2. Further, it reaffirmed two cases, Aspen Skiing and Ottertail, existing cases in which the Supreme Court found antitrust violations involving refusals to deal. To understand what a purpose to obtain or retain a monopoly is, we need to examine those cases. In Aspen Skiing, a dominant ski resort, cleverly named Ski-Co. Wow, this is a really, really quiet car. Which is fine. But Ski-Co had offered a joint ski pass with a smaller neighboring rival, Highlands. Now, eventually, Ski-Co terminated the relationship. It also refused to sell either at a discounted price or at full retail its passes to Highlands so it could recreate this joint product. Highlands sued, alleging the refusal to participate in that joint ticket was exclusionary. So based on its review of all the evidence, the Supreme Court upheld the jury's finding of liability. The Trinco court described Aspen Skiing at or near the outer bound of Section 2 liability. 2 points. 1, it didn't say it was outside that boundary. 2, being on the boundary of liability does not mean Aspen is the sole situation in which a refusal to deal violates the antitrust laws. Indeed, Ottertail Power Company versus the United States, which Trinco also reaffirmed, condemned a refusal to deal on different facts than Aspen Skiing. Ottertail, interestingly enough, still exists, had a monopoly on the transmission of electricity at the wholesale level, but it also provided electricity at the retail level. Now, certain municipalities wanted to enter that retail market and actually provide the retail homes and businesses electricity directly. However, Ottertail refused to sell electricity at wholesale to those municipalities. The utility also refused to transmit electricity if the municipalities found another power company or co-op to sell them electricity at the wholesale level. The Supreme Court concluded that Ottertail's refusals were designed, quote, to prevent municipal power systems from eroding Ottertail's monopolistic position. Whether there was a prior dealing was not a factor at all in the court's analysis. Now, there was also evidence of Ottertail's subjective intent, and Ottertail failed to offer a legitimate justification. The critical issue for the court, however, was that utility provided the same services to other customers that it was denying to these municipalities. And as the Trinco court explained in reaffirming Ottertail, a refusal to deal could violate Section 2 of the Sherman Act, where, quote, the defendant was already in the business of providing a service to certain customers and refused to provide it to certain other customers. So why was the result in Trinco different? Well, the Trinco court effectively held that no jury could have concluded that Verizon's refusal to deal had the purpose of maintaining its monopoly. As the court said, Verizon's reluctance to interconnect at the cost-based rate of compensation available under the Telecommunication Act tells us nothing about dreams of monopoly. There was no prior course of dealing that would suggest the relationship was profitable as an Aspen, nor was Verizon conditioning its dealing in a way that would thwart competition, as in the Lorraine Journal. Verizon had not refused to provide the services on terms it offered other customers in Ottertail. Indeed, Verizon hadn't offered the service it issued to anyone. So Trinco then does not define mandatory elements. It engaged in and in Aspen, the court engaged in a very typical appellate review of assessing whether there was sufficient evidence to support the jury's verdict. And it should be clear that under the test the Facebook court announced, Otter Tail should have come out the other way. Indeed, under the Facebook test, one would wonder whether the government had a viable theory to challenge AT&T's phone monopoly. The breakup of AT&T, which separated its long-distance business from its local monopolies, the Verizons of the world, was one of the most important monopolization cases in US history. Now, the core of the government's case was that AT&T refused to connect a competitor's long-distance network with AT&T's local phone network. And that refusal protected AT&T's existing monopoly. Right? So no point in offering long-distance calling, right, from New York to California if you can't then deliver the call to the ultimate person in New York or connect from the people in California. Nothing in the government's case relied on the pre-existing relationship between AT&T and potential competitors or whether AT&T was interconnecting other people or not. So the real Trinco, the one behind the curtain, created no rigid test for analyzing refusals to deal. That test cannot be reduced to a checklist that applies in any case. Rather, the analysis is fact-intensive. The overarching question is whether the monopolist had a purpose to acquire or maintain a monopoly. Now, and a variety of evidence bears on that question, as we've discussed. So as you listen to the panels today, and if refusals to deal comes up, make sure it's not the big, ugly, disembodied green head surrounded by flames intoning absolutes and deep foreboding voices versions of Trinco, but the real version, the one that's often behind the curtain. So specifically, refusals to deal applies to a limited and discrete set. Let me try that all one more time in English. Specifically, refusals to deal applies to a limited and discrete category of conduct, a company's decision not to deal with its competitors. So if the challenge action involves a refusal to deal with a customer, Trinco and its progeny are irrelevant. If the monopolist will deal with the company only if the company must refrain or limit its dealings with others, it's not a refusal to deal. If a digital platform has invited and encouraged connection to the platform to increase that value of the platform, we are no longer in the world of refusals to deal. Neither the law nor the policy concerns about requiring companies to deal with each other applies in these situations. And even where a digital platform has simply refused to deal with a competitor, the question before, in, and after Trinco is whether the digital platform has a purpose to create or maintain a monopoly. That question, like many in the law, is quantitative. Did the platform previously deal with the company? Does the platform deal with others on terms it won't offer that company? Do we think the collaboration is something the market wants? Does the refusal limit existing or future competition? Is the refusal profitable? Only because it limits competition. Is the platform not dealing with a company because it would be too expensive or for other reasons unrelated to limiting competition? That's all illustrative, not exhaustive. And the point is, any of that evidence bears on the ultimate question. And in the context of refusals to deal, it's important to realize that digital platforms, that the policies underlying refusal to deal law are weaker in considering the platforms and digital platforms than the networks of the 20th century, rails and phones. Right, the old style phone system, as I said, required substantial physical investments in wires and laying cables. In addition, interconnection or sharing network could also be expensive, and that expense usually actually fell on the network. In contrast, digital platforms are somewhat different. They have massive economy scales, so the bigger they get, the lower their costs. And interconnection is generally critical to their success. So it's a feature of the marketplace, not a bug. The physical infrastructure is less costly than the traditional phone network, and often the cost of interconnection is low and falls on the party wanting to interconnect. Those differences should affect how courts analyze refusals to deal in this context. So as we leave the land of Oz, I want to leave you with two thoughts. Defining refusals to deal too broadly would create a loophole allowing anti-competitive conduct that will increase prices and reduce innovation. And although refusals to deal with competitors often may not violate the antitrust laws, when they do, the impact can be devastating. Thank you for the privilege of speaking to you today, and I'm happy to answer any easy softball questions.
We have a number of questions that focus on the technical doctrine that you're speaking about, but one of the interests of our listeners focuses on your career in public service. And at a very young age, Michael has had an astonishingly broad range of experiences in public service, a law clerk to a judge, that's the judicial side, aide to a senator on a legislative committee, several years working in Congress, a number of years working at the Federal Trade Commission, the Administrative Commission, both as a case handler, working on crucial matters related to pharmaceutical sector, healthcare generally, as an advisor to a commissioner, and for several years, John Leibowitz, the chair of the Federal Trade Commission, and now at the Department of Justice. Not only do you rarely see this span of experience across all the branches of government, and I think Michael has a few careers left in him yet, in that entire span, but also seeing public service from the engine room at the FTC as a case handler up to the bridge, where he stands now. It's an astonishing array of activities, and largely connected to work in the public service. Can you talk for a bit about what's attracted you to that path in your career, where in Washington we're called in for stints so often with the private sector to something else? Can you just say a bit about what's motivated you to take the path you have with so much of it focused on public service?
So, it's always a little scary to be asked questions by Professor Kovacic, or to talk about case law in his speech where he's in the audience, so I'm worried for what's coming next. And the first question, let me start by giving you perhaps a less inspiring answer of why I looked to antitrust. It was in 8th grade, so antitrust was cool back then. I was deeply depressed because I had been cut from my baseball team. So I figured professional baseball was out of the question. My parents smartly would not let me play tackle football. And I could tell by looking at my family and my grandparents that I was never going to play basketball. So it was clear there was no career in professional athletics. And
So wickedly unfair, isn't it?
yeah, what else was there to do?
Who knows if that counterfactual might happen?
So I'm reading a book on history, American history, and it's talking about Teddy Roosevelt. And it refers to him as a trust buster. And I very much remember sitting, lying on my bed, reading this book, being like, trust buster, that sounds cool. And that sounds like you don't have to have a lick of athletic talent. So I am convinced that that one moment, deep in my subconscious, drove me to be interested in antitrust. But what has always interested me, and it does refer back to that in some sense, 8th grade moment, is that antitrust is fundamentally about the rules of the game. It's about making sure everybody has the opportunity to succeed on their merits. And that seems critical to me, has always been critical to me, to the health of a democracy. And that may sound corny, but I'm still the guy 20 years later when he walks across Pennsylvania Avenue, gets butterflies in his heart when he sees the Capitol, regardless of who happens to be in it or trying to get in it or protesting in front of it. And so I think from an early age, I always saw antitrust as related to broader policy goals. And I think what the history here is, I'm a law clerk, have all these big ideas, and I spend 2 years in the district court realizing that litigation is hard, it's fact-specific, it depends on lots of little things that don't involve big things. Did you get the right admission in the deposition? Do you know the rules of evidence? So when I went to the FTC, I very much wanted to be a line attorney, because I figured you could only achieve great results if you understood how to fight the battles. So that would, and then at some point, I wanted to see it from the other side, and that's when I worked for Commissioner Leibowitz. And one of the things I really learned from that is that there is always a tension between the timeline horizon of the politicals. And I don't say that in a bad way. We have a system where presidents appoint people to make policy decisions, and that's incredibly important. And their timeline is incredibly short, especially in antitrust timeline, versus the staff. And there's a challenge there of how do you get everybody on the same page? Because it's not that there's a right or wrong answer. It is not always, let's just go to court, let's bring lots of cases, let's do this really fast. But also, if you take too long, you can miss the moment. And one of the things I did see at the FTC is sometimes we took so long building a case that it was too late by the time we found it. So that, to me, was a challenge. And then from the legislative perspective, thinking about how do you get better results in the court? What can Congress do? And really all of that then led me to a think tank where I spent a couple of years trying to really put all that together, and hopefully that has helped me to be a more effective deputy.
And I mean, it sounds to me, in many ways, as though you're taking courses in a curriculum, a life's curriculum. Each one has put you in a better position to do the job that you have now. But in so many ways, never forgetting that guy who was the case handler, having to work in the first instance. This is a valuable accumulation of experience that really prepares you for what you're doing now.
Well, hopefully also the staff at the DOJ would say that as well.
Yep, I'm sure they do. I'm sure they do. And I mean, I would sense it's, you know, having had both of your experiences in this respect, I sense it's very heartening to them to have someone in the front office, in your case, others as well, but someone who understands that, understands the tension. So that's a great benefit. If you can reflect for a second on your experience looking at the development of policy over time, and that is quite an inspirational view that you have on Pennsylvania Avenue, either stepping out of Main Justice or the FTC. You look at either end of the avenue, and it's quite remarkable, I find, especially in the evening when the lights come up on the Capitol Dome. You look in both directions. It takes a fairly hardened heart not to be moved a bit about that. What do you see that's distinctive about this moment in our development of antitrust policy? One of our listeners would like to have your thoughts about what's special about this time compared to the others, as someone who's seen the development of policy from that perspective over time. What's special now?
So sociologically, really shouldn't be saying that probably, but I think the great challenge of our time is we face an era of increasing inequality. And that makes people angry, and that makes people upset, and that means, you know, Josh said this last, I think people are looking everywhere. And all of a sudden you have policy makers, elected officials saying, wait a minute, maybe the economy isn't so competitive as we thought it was. Maybe the sort of light touch that reflected the antitrust consensus of the late 20th century, maybe it went too far. Why is that important? Because that means that there's, for the first time in my lifetime, a counterbalance to the folks who basically, for 40 years, told us, yeah, antitrust on the margins is fine. You know, we really have to be more concerned about over-enforcement. And let me give you a specific example of what I mean. One of the things that the commission, the FTC, has been lambasted for was not bringing a Google case back in 2012. Look, people have every right to criticize that. I'm not that, you know, but I'll tell you this.
I was gone by then, by the way. That wasn't my call. Go ahead.
If you were, you know, if you were to go back in time, there was not public pressure to bring the case. virtually everybody was worried that a case against Google would destroy a national championship. That means internally, it doesn't mean staff doesn't do their job. It doesn't mean the political decision makers are deciding on inappropriate basis, but it means all the risk you think about is the risk of losing or bringing in an inappropriate case. If that's going on for 40 years, it's going to lead to not sufficient antitrust enforcement. Now, the agencies can be aggressive because there's a president who says, it's my policy that we need to do something different. You have major senators saying, we need more effective antitrust enforcement. So you can bring cases, and you might win them and you might lose them, but it's not as though you're going to look like you're out beyond the political establishment. And that's really important because law enforcers, and particularly in antitrust, we have this relationship between we're enforcing the law, but it's a political issue. And so the moment here is, for the first time, maybe in a century, there is political support and willpower to think about antitrust enforcement in different ways and to be more aggressive.
We could turn for a moment to refusals to deal. Now you document very well in your presentation how some crucial nuances that were clearly reflected in the older jurisprudence seem to have basically disappeared in modern treatments. Look language in Colgate, where the court prefaces its famous admonition about the right of a trader to pick those with whom it will deal, the introductory clause, in the absence of any purpose to create or maintain a monopoly. The fact that Aspen was a unanimous decision, there were no dissents. When you look at the authority cited in Aspen, it's a wide range of authorities anchored as much in the work of Robert Bork as anyone else. That's how Stevens wrote the decision. Why did these important elements of our jurisprudence fade out of sight? That is, why would the court in Trinco have this dismissive comment? It's at the fringe, at or beyond. No, it's a unanimous decision. Why did these fade in their power to guide the jurisprudence, and how can you bring them back into focus in handling future cases?
So that's really an easy question. I'm just going to say yes. No. Look, I mean, it's a challenging question.
The language has always been there, as you said. It's right there in the text.
So as others have said, this is a common law doctrine. So language appears and disappears in the case, in the case law. And I think it's the responsibility of the Department of Justice and other antitrust enforcement, Federal Trade Commission, state AGs, plaintiffs, where they see a problem in the marketplace, not to start by saying refusals to deal are basically legal, but to say, here's the problem. Does the law provide us a path to argue that it violates? Does case law allow us to argue that there's a violation? And to put to the test whether the courts will apply the law as it exists, or whether it really has turned down this path of saying, basically, refusals to deal are virtually never anti-competitive, right? And so let me give you just a brief example. There's an issue that when Bill and I were at the FTC that came up involving pharmaceutical products, where branded companies basically would refuse to provide products to generic companies. And the generic companies absolutely, by law, had to have these products to get approval. I'm not going to go into the deep regulatory reason why they couldn't get it anywhere else, but they couldn't in certain circumstances. So if you read Trinco, if you sort of have that Facebook court view of this, of refusals to deal, it's not a problem. So you could bring a case, it can be really hard, or it's actually a case where eventually Congress stepped in and said, we're not going to wait for the courts. We're not going to wait to figure out where antitrust law is leading us, and then we passed a statute called the Creates Act. So part of this is also bringing, rather than saying we assume the law is in a bad place, and the response you get is, well, how do you know you didn't bring the case? Part of this process is is the law in the right place, and forcing the courts to decide that as a step in the policy discussion.
And you're indicating the importance of this ongoing process of what Joel Klein called the conversation with the courts that agencies have over time. And the only way to carry out that conversation is to have cases where you're appearing before them. I'm putting aside amicus appearances, but you're bringing a collection of cases to raise the points, doing the teaching that you're describing here. I guess as part of that, I loved your Otter Tail example. I suppose you want a portfolio of cases. They're not all blockbusters. You have a case like Otter Tail, which was a small case that made big law. It's a platform for AT&T that when you're formulating a program, you want an array of matters where you're coming to the court, not just once every 5 years, but on a regular basis. Is that a sensible strategy to follow?
Yes, it is. The sort of what I like to call strategic enforcement, right? Which is, on the one hand, in antitrust law, we have pre-merger, pre-consummation review. So part of your agenda always depends on what comes through the door. But part of a good in antitrust enforcement, and why I think this looks a little different than, say, criminal enforcement, is the agencies do have a duty to find problems and try to fix them. And sometimes that's bringing a big case, AT&T. Sometimes that's bringing a smaller case, Otter Tail. Sometimes that's bringing a really small case. There's the FTC during the Bush administration brought a case challenging a joint venture for selling 3-tenor CDs. But that case helped establish a quick look or a hybrid approach to address a rule of reason case that was not overly burdensome, that has been used by the FTC in many other cases. So these are all the sort of policy things you have to juggle. And it would not surprise anyone if you read Jonathan Cantor's speech. He's his eyes are very big, and a challenge is how we make sure we can actually, it can all fit in our stomach.
And you mentioned Lorraine Journal, another case that viewed in isolation, who'd care about a interaction between a newspaper and a radio station on the north coast of America in Ohio, but provided the tool that was enormously valuable over time. I have another case, another question about refusals to deal. How might the concept apply to the practice of what's called self-preferencing, where a firm does not necessarily say, we'll never deal with anyone else, but the terms of the dealing are such that the firm's own products get priority, the others are subordinated. Is there a role for a refusal to deal doctrine in analyzing self-preferencing allegations?
So I'm going to pass on that question given existing litigation. I think, except to say, consistent with what I said in the speech, I think you need to look at, is the self-preferencing fit within the very narrow category of refusals to deal? If the answer is that's yes, and I don't think you can say that generally. It would depend on the facts of the case, the industry. If it is, then the question would be, can you show, based on all the facts, that there's a purpose to create or maintain a monopoly? If looking at the self-preferencing it does not fall within it, then you're going to apply the relevant precedent. So, one of the things I struggle with that type of question is it's just not the way I think about antitrust enforcement. I think about you investigate, you see if there is, you try to identify what the competition is that's at stake, what the conduct does that changes it, and whether that's good or bad. Once you know that, I think the legal analysis should follow from that. And I think one of the problems the enforcers had, and I include myself, is when I was young, it was like, no. From the day somebody comes in with a complaint, you write out all the elements, and the first thing you're focusing on, what's the market? Okay, well, you're going to have to figure that out sometime, but shouldn't you know whether you think what's going on is problematic before you figure out what the market is?
I have one more from our listeners, and it deals with a sector we mentioned before today, agriculture. As you know, when you look at the president's whole of government approach, there are plenty of sectors there that are not tech. Agriculture is one of them. Can you say a bit about what's taking place in the department now, both with its own work in the Antitrust Division, but in collaboration with other units of government to develop a whole of government approach to agriculture and competition?
Yeah, so agriculture is incredibly important. Actually, when Jonathan and I were talking, and I was trying to successfully convince him to hire me, he asked me what I wanted to work on. So you might think I would say healthcare, because I'd done that so much at the FTC, digital markets, high tech, because that gets all the headlines. Actually, what I said to him was, ag. Jonathan, I want to work on agriculture and antitrust. Because I think that is an industry that is highly concentrated, and when you go talk to market participants, you hear the types of concerns that raise troubling issues regarding antitrust. So we are looking very closely. Last year, we entered a consent decree with 3 of the major chicken processors. That allegation, the complaint alleged that there was an information sharing going on about worker compensation that had been going on for 20 plus years at least, where they were sharing the most granular of data about what they were paying workers. They were meeting and talking about it, and they would sometimes even call each other up. And so that consent is unique in 3 ways. The first is we obtained restitution so that the workers could be compensated. Second, the parties agreed to a monitor, not just to the antitrust, not just to enforce the consent, but the monitor actually has oversight over any potential antitrust violation in their chicken processing. So whether it be workers, growers, downstream. That's a pretty unique consent decree. And that leads us into the third one, which goes to the other, is there is a statute called the Packers and Stockyard Act that was passed in 1921. So I'm going to I wrote a long 100-page report about one section of the U.S. Code, but I'm not going to bore you with it.
Oh, no, that's exciting.
But that had, the people had it had lines basically fallow. And when it comes to chickens, the USDA is primarily responsible for enforcing it. But when it comes to chickens, it's the Department of Justice brings cases referred to it. And we also brought a Packers and Stockyards claim saying that the way the processors were compensating their chicken growers, which if you don't know is just really mind-boggling, like so troubling that John Oliver did a whole segment on it. But so we brought an allegation that said the way they contract with the chicken growers is deceptive, which is a violation of the Packers and Stockyard Act, and they have changed their process. So, it doesn't get sort of the attention that high tech does, but I think it's a really important area for both because of the concerns and because it really does affect people in rural America, middle America, and has, I think, arguably can have really devastating effects that go just beyond the direct effects of anti-competitive conduct.
And a real possibility inherent in the executive order is engaging in a coordinated way all these resources of government to address the phenomena. Michael, thank you very much on behalf of the Journal for this presentation. I hope that all of you have the strong sense that when you're thinking of who you want in positions of high responsibility in the public enforcement agency, you're looking at them right here. That's the experience and perspective you want to bring to bear on the process. And it's not enough to guarantee success, but I don't know what prospect for success you have if you don't have that as a starting point. Thank you, Michael.
Awfully kind, Bill.